Today we are going to be looking at the area of remedies for non-performance. When one of the parties to an agreement fails to perform its contractual duties, a number of possible solutions are available, namely 1. The remedies chosen by the parties themselves in the contract document. 2. The common law remedy of damages. Or 3. The different equitable remedies such as specific performance and injunctions. Let's first look at the choice of the parties. As we have seen, frequently the parties to a contract seek to control the question of non-performance and loss themselves. This can be done in a number of ways. 1. A release and waiver of liability clause. The parties to a contract may decide to insert a release and waiver of liability clause into their agreement. Under such a clause, one party gives up its right to sue the other party in the event of their suffering loss linked to the performance of the agreement. A hold harmless and indemnification clause. Alternatively, the parties may agree to insert a hold harmless and indemnification clause into their agreement. The purpose of a hold harmless and indemnification clause is to transfer the risk of liability arising under the contract vis-à-vis third parties from one of the parties to the agreement, referred to as the indemnity, to the other contractual party, the indemnitor. Liquidated damages clauses, or LDC. Instead of transferring risk, the parties may alternatively agree to establish in advance the amount of damages that will become payable in the event of a specific case of non-performance of a contractual duty by one of the parties to the agreement. This is done by the inclusion of a liquidated damages clause in the contract. Exclusion or exemption of liability for specific damages. Finally, the parties may decide to exclude liability for certain types of loss. For example, sometimes the parties will exclude or exempt liability for consequential or indirect damages, which may be considered as potentially too burdensome. Both LDC and exemption clauses, excluding liability, are policed strictly by the courts. Now let's take a look at the common law remedy available for breach of contract, namely financial compensation. The only remedy available in the common law is financial compensation, either taking the form of damages or restitution. The object of an award of damages is to put the injured party in the position it would have been in had the contract been performed. According to the courts, damages should be quantified having regard to principles of reasonableness, foreseeability, and proportionality. Punitive damages are not recognized in common law contract law. There are several different types of damages available at common law. The first being nominal damages. Nominal damages are awarded when it is established that there was a breach of contract but that no actual loss occurred as a result of such breach. Compensatory damages. Compensatory damages, also referred to as unliquidated damages, seek to compensate the plaintiff for injuries and losses sustained as a result of a breach of contract. When calculating compensatory damages, the courts have a number of different headings under which such damages may be awarded. Expectation loss. Expectation loss, also known as loss of a bargain, seeks to put the claimant in the financial position it would have been in had the contract been performed. Reliance loss. This is also known as wasted expenditure loss and occurs if the claimant incurs out-of-pocket expenses in preparation for or in partial performance of the contract. Loss for distress and disappointment. Normally, in commercial contracts, damages will not be awarded for distress and disappointment. However, in the case of consumer contracts, if the main purpose of a contract is pleasure or enjoyment, the courts may consider it reasonable to award damages under this heading. Instead of applying for damages, sometimes a plaintiff can instead seek a solution under the heading of restitution. The object of restitution is not to compensate the plaintiff for loss, as in the case of compensatory damages, but rather to prevent the other party from enjoying an unjustified benefit. Thus, as such, it is not a remedy for breach of contract, but rather a remedy that permits property or its financial equivalent to be restored to another party where the property right has been abused. Unlike expectation loss, restitution is calculated by reference not to the plaintiff's loss, but rather to the defendant's gain. Now let's take a look at the limits imposed on the damages that may be payable. The courts have established a number of principles limiting the damages that may be available following a breach of contract. The first of these is causation. For a successful claim of damages at common law, there must be a causal link between the defendant's act and the subsequent damage suffered by the plaintiff. Thus, it is necessary to show that the party's breach of contract actually caused the loss at the origin of the action. In technical terms, it is said that the breach must be the dominant or effective cause of the loss. Thus, if an intervening act breaks the chain of causation, the defendant will not be considered responsible for the resulting damage. Remoteness. Even if the requirement of causation is satisfied, the ensuing loss must also have been reasonably foreseeable by the defendant if liability is to attach. Thus, the courts look not to the amount that is lost, but the amount that could have been reasonably foreseen. In Transfield Shipping and Mercator Shipping, Transfield returned a boat they had chartered from Mercator 9 days late. As a result of the late return, Mercator lost a particularly lucrative charter contract they had for the boat and sued Transfield for this loss, which was significantly in excess of the normal market loss that could have been expected by Transfield. In the opinion of the court, given that Transfield had no special knowledge of the other lucrative contract, the late return left Transfield liable for damages in the amount of the daily normal market rate payable for chartering the boat, and not the greater amount actually lost by Mercator Shipping. Mitigation. Finally, the victim of the other party's non-performance is expected to take all reasonable acts to limit its losses, and by the same token, not to take unreasonable steps that may increase them. Indeed, it is a general rule of the common law that a party cannot recover for loss where it could have avoided or mitigated such loss through the exercise of reasonable effort. Now let's take a look at the equitable remedies available for breach of contract. In certain circumstances, an award of pecuniary damages is clearly not an appropriate way to compensate a party for non-performance of a contractual duty. In such a case, the courts, instead of ruling in common law, may choose to exercise their discretionary equitable jurisdiction. When deciding whether to rule in equity or not, the courts have a number of maxims or rules to which they refer, including 1. Equity will not allow a wrong without a remedy. 2. Those who seek equity must themselves act equitably. 3. Those seeking equity must do so quickly and not hesitate. Or 4. Equity will not allow a statute to be used in order to hide a fraud. Mostly these rules work to restrict the application of equity, which, as a fundamentally subjective remedy, threatens the certainty of the common law system if applied too broadly. Equity has a number of different remedies that may be available for claimants should the courts consider the common law remedy of damages inappropriate. The first of these is specific performance. An order for specific performance is an order requiring a party to perform specifically its duty in accordance with the terms of their contract. As an order of specific performance is an equitable remedy, it is in the discretion of the courts whether it should be granted or not. Normally, an order of specific performance may be awarded by the courts where the goods are unique. The courts will not be inclined to make an order of specific performance if they consider that it will not be possible for them to supervise the ordered performance. Finally, when deciding whether to grant an order of specific performance, the court will consider the difference between the benefit that one party will gain from the granting of the order and the cost of the performance to the other party, and where the cost is disproportionate to the benefit received, this will constitute a factor against the making of any such order. Injunctions. An injunction is an order from the court requiring a party to refrain from certain behavior. As in the case of specific performance, the courts may choose to grant an injunction where it is demonstrated that damages are not an appropriate remedy. There are three main types of injunction. Prohibitory injunctions. A prohibitory injunction requires the defendant not to do something. Mandatory injunction. A mandatory injunction requires the defendant to do something in the sense of undoing something that has already been done. For example, if X constructs a house in breach of his agreement with Y, Y may request a mandatory injunction from the court ordering X to tear down the illegally constructed house. Interim injunction. An interlocutory or interim injunction is a temporary, equitable measure aimed at preserving the status quo. Under an interim injunction, a party may be temporarily prevented from acting so as to allow a court to rule on the legality of its behavior. Now let's look at some other remedies available in equity. Rescission. Under an order of rescission, the contract between the parties is cancelled, returning them to their previous position. This remedy is often sought in cases of misrepresentation, reformation, or rectification. Normally, the courts will not interfere and change the terms of an agreement between the parties. However, where a drafting error has been made, the courts may be willing to redraft the terms of the agreement to correct the error. This is referred to as reformation or rectification. In specie, restitution. This is where the court orders unpaid for property acquired by one party to be returned to its rightful owner. Now let's have a look at the limitations as regards the availability of remedies in contract law. Apart from the limitations that the parties may themselves apply in their agreement, different legal limitations also apply as regards the availability of contract law remedies. First, let's look at the limitations on the common law remedy of damages. Pursuant to the terms of the relevant Statute of Limitations Acts, actions for breach of simple contracts in the UK are subject to a 6-year statute of limitations period. As regards speciality contracts, the statute of limitation period is 12 years. Now let's have a look at the limitations on remedies available in equity. The statute of limitations periods referred to above do not apply to actions taken in equity. Instead, there is the equitable doctrine of laches, according to which each case is evaluated on its facts so as to decide whether the plaintiff has allowed too much time to pass before seeking a solution in equity. We hope you enjoyed this introduction to the area of remedies in the area of common law, contract law.